Welcome to our podcast series, where we provide expert insights into evolving areas of litigation. This series is brought to you by the barristers at 4 New Square Chambers. Over 6 episodes, we'll be exploring key trends in ESG and related litigation. My name is Saaman Pourghadiri, and together with Anson, Cheung and Daniel Saoul KC, we'll be discussing ESG and fiduciary decision-making, particularly involving directors and trustees. In this episode, we're going to be discussing ESG and fiduciary decision-making, both in the context of company directors and trustees. And we're going to start by discussing a fascinating case, the one which some have said reflects something of a missed opportunity on the part of the judiciary. The case was one in which Dan acted for the applicants, ClientEarth, in their derivative claim against the directors of Shell. So Dan, perhaps you can tell us a little about the ClientEarth and Shell case.
Thanks, Saaman. Yeah, I mean, this was a fascinating case. And I know you're always quite keen to talk about the cases I've lost rather than the cases I've won. But this really was an absolutely fascinating case to be involved with. Given my involvement, I'm going to try and describe it and talk about it relatively neutrally. Although, as you say, there have been various market commentators who've expressed views which we can talk about. The claim brought by ClientEarth was a derivative action against the board of directors of Shell, seeking to hold those directors responsible for failures that ClientEarth had alleged. It was a claim which was supported not just by ClientEarth, but by a number of institutional investors. And essentially, the allegation made by Shell was that whilst Shell and its board had adopted a number of targets and strategies with a view to achieving net zero in 2050 and more generally dealing with the threat to its business raised by climate change. At the same time, ClientEarth alleged, the board had set inadequate targets and was adopting inadequate means to achieve the company's publicly stated energy transition objectives. And so the case advanced was essentially that the approach being taken was not reasonable and not rational and outside of the board's latitude of decision-making. Now, as you would expect, Shell rejected these criticisms. It emphasized, amongst other things, that these were very complex assessments. Its business was a substantial one, and there were many factors to be weighed one against the other. They maintained that due care had been taken when reaching their decisions, and that these were quintessentially matters for the board acting within its discretion, in respect of which it should be granted a substantial latitude. Now, it's well known that the court reached clear conclusions in favour of Shell. Now, I want to emphasise it was conclusions on threshold questions because the application being considered was the application by ClientEarth to proceed with the derivative action, to continue the claim, where it was required to demonstrate essentially a prima facie case. Now, let me just summarise briefly the court's conclusions here, focusing on the big points. First of all, the court emphasised that a derivative action will represent an exception to the usual principle, and that principle is the one established and enshrined in Foss and Harbottle, that it's for the company generally to decide whether to pursue a cause of action against a director. Secondly, the court referred to what it described as the well-established principle that it's for directors themselves to determine how best to promote the success of the company, and that the weighing of different factors in the context of reasonable and indeed good faith decision-making is a matter essentially for the board. And finally, on that topic, the court considered that to even begin to contemplate intervening in that assessment and to scrutinise the board's decision-making from a judicial standpoint, it would have required expert evidence. And instead, what ClientEarth had produced was a witness statement and exhibit which was substantial and were a compendium of a material drawn from third-party sources, which were designed to suggest that there was a substantial body of opinion to the effect that Shell's approach was not going to meet its objectives. The final point that the court deployed in support of its conclusion was its view that ClientEarth was actually bringing the proceedings for an ulterior purpose. That is, not trying to promote the success of Shell, but rather promoting its own policy agenda as a not-for-profit body that seeks to achieve climate-related objectives largely through the law. And then in addition, there was effectively a final kicker so far as the parties were concerned, which was the costs order. Shell applied for its costs, notwithstanding the usual rule that at the prima facie stage there is no adverse costs order in favour of the respondent board. But the court in this case decided that it should disapply that principle and awarded Shell its costs. So a number of important conclusions there that serve effectively to constrain the ability of parties to deploy the derivative action and essentially bring into view the principles that are found in the authorities, and to emphasise that they're not going to be departed from in ESG-related cases. I think the article you were implicitly referring to earlier, Saaman, when you were saying that some people took the view that this was a missed opportunity, is the article of Lord Carnwath, which was published early this year. And as you say, that was his view, that this was a missed opportunity. He thought the requirement for expert evidence at the earliest stage in the case was onerous. He took the view that what he considered the dissonance between Shell's proposed strategy and its current approach would have merited further inquiry. And he also took the view that it was pretty harsh, in his view, to conclude that ClientEarth was pursuing an ulterior motive, when Lord Carnwath's view, and I suspect ClientEarth's view, is that ClientEarth's policy agenda goes hand in hand with its desire to see Shell operate differently. Now, that is just one view, of course. It's not the view of the court. And we are left with the judgment, which we now have to engage with.
Yeah. And, from my perspective, it struck me that the challenge that ClientEarth was bringing was a very carefully calibrated challenge. So this wasn't, ClientEarth hadn't picked a target where they were disputing the overall policy that the company had chosen. They were running with the policy the company had chosen. And they were just saying the means the directors have chosen to achieve that is irrational and unreasonable. And that kind of challenge struck me as one that would be more likely to find favour. But that sort of shows what I know. So that's the approach in the ClientEarth case to derivative claims. Anson, have you seen the courts adopting a perhaps more generous procedural approach in other fields, in other areas?
It's really interesting you say that, and certainly some of the alternative routes that people have considered instead of a derivative action are, for example, breach of warranties under a share purchase agreement, a claim in deceit. Coming on to what I really want to talk about, which is the Section 90, Section 90A FSMA claims. Now, it's particularly interesting because a number of 4 New Square's members, Graham Chapman KC, Shell Patel KC, and William Harman, were recently successful in the Court of Appeal in a case called Various Claimants and Standard Chartered PLC. And they were defending a strikeout application brought against them on a Section 90, Section 90A FSMA claim. I suppose just for our audience's benefit, so Section 90, Section 90A FSMA provide a potentially quite valuable right for shareholders to sue UK-listed companies that publish misleading information to the markets. And these sections provide for compensation to be payable in certain circumstances where, for example, there have been misstatements or omissions in prospectuses or other published information relating to securities. Particularly interesting, and I suppose you might have thought quite a high bar, was that in order to establish liability of an issuer under Section 90A and Schedule 10.8 of FSMA, knowledge and dishonesty on the part of persons discharging managerial responsibilities must be proven. But I think in contrast to the sort of slightly unexpectedly high evidential bar that ClientEarth faced, the Court of Appeal clarified in Standard Chartered that there would be a measure of generosity given to claimants, where, for example, there was a need for proper particularization where allegations of fraud and dishonesty were made. The courts, quote unquote, need to be aware of imposing such onerous pleading requirements as to make it impractical to bring meritorious fraud claims, particularly given the limited information that might initially be available to a victim. Now, an example of this was actually shown in the strikeout application, because in terms of particularizing the persons discharging managerial responsibilities, the defendant had argued that pleading en bloc against the executives was unacceptable. But of course, there was a bit of a problem because the bank had refused to disclose who actually were the persons discharging managerial responsibilities. So query how the claimants were supposed to particularize that in the first place. And the court was clearly alive to that and said, well, for the time being, this is going to be sufficient. And I think that perhaps quite contrasts with how ClientEarth was dealt with, requiring expert evidence to even establish a prima facie case. Whereas I suppose in Section 90A FSMA claims, the Court of Appeal took a rather more lenient approach. And I suppose given the court's reluctance to sort of go down the derivative action, breach of directors' duties, we'll no doubt see an increasing trend of Section 90 and Section 90A FSMA claims. But of course, if you want to know more about these claims, we are covering securities fraud claims in a separate podcast, so stay tuned.
Click like, click subscribe, and so on. And of course, ClientEarth wasn't the only example of a recent derivative claim where the court has set up procedural hurdles. Dan, do you want to tell us a little about the McGaughey claim?
Yeah, thanks, Saaman. So this is the other significant decision in the derivative action space concerning the decision-making by directors in an ESG context in the last 12 months or so. So this was a claim brought by two academics who were members of an occupational pension scheme, and they were seeking to challenge decision-making by directors of the trustee and administrator of the scheme in relation to investments that the scheme had made. Now, they did this by bringing a derivative action, or the equivalent of a derivative action at common law, alleging, amongst other things, breaches of duties by the directors in continuing to invest in fossil fuels, despite the scheme's stated ambition to be carbon neutral by 2050. And they also alleged a failure to consider related financial risks. And I would add that there were other alleged breaches of duty which were not ESG-centric. Now here, this claim was dismissed by the Court of Appeal on other grounds at the threshold level again. They were different threshold issues on this occasion than in the ClientEarth case. The first was a failure to demonstrate any loss or harm suffered by the company, which might give rise to an indirect or reflective loss by the claimants. And the Court of Appeal emphasised that that is a requirement for a derivative action. I seem to be struggling, Saaman, to say the word, so I'll just skip it for the rest of this podcast. I'm not going to say it again. Now, other problems that the Court of Appeal noted were a failure to meet the substantive prima facie test for relief, in failing to make good the contention that the directors had benefited improperly as a result of their alleged misconduct. And then the court also noted that there were probably other more direct routes of recovery or recourse available, such as a claim for breach of trust, although the court was careful not to suggest that those claims might succeed, and indeed the likelihood is they would have run into other procedural problems and hurdles. So where does this leave us? It leaves us with two significant decisions by the courts in the context of these actions, emphasising the rigour which will be applied when you try to bring a derivative action, emphasising the exceptionality of this remedy, provoking, I would have thought, a sigh of relief in many boardrooms, noting that there must be many companies now grappling with ESG issues, climate change issues, how to respond, and the suggestion that that decision-making could be scrutinised on a blow-by-blow basis must have been troubling to them. And these decisions will, I expect, come as a relief, albeit they will also now challenge those who want to bring such claims to effectively raise their game and meet the stringent tests that have been set down.
So that's the approach, I guess, English companies will be dealing with. What have we seen in the rest of the common law world, Anson?
There's two cases that come to mind, one in Singapore and one in the New York State courts, both interesting, I suppose, for their own reasons. The first case, the Singaporean one, Cheung, Serene and HC Surgical Specialists Limited. This one, I suppose, as opposed to the more environmental challenges we've seen in ESG cases, is dealing more with the social and governmental side. Because the background is, I suppose, a Me Too background. So be appropriately forewarned. This was an acquisition by HC Surgical Specialists of 19% of a company run by someone called Dr. Ong. Now, the claimant had been in a relationship with Dr. Chan, who was Dr. Ong's friend. And she discovered that not only was Dr. Chan cheating on her, but he and Dr. Ong had been sharing their sexual exploits with each other via WhatsApp. And in one of these messages sent by Dr. Ong, it was alleged that one of the women that he had apparently had sexual relations with was his patient. So it's safe to say that Ms. Cheung was pretty upset. She first made a complaint to the Singapore Medical Council that Dr. Ong and Dr. Chan took advantage of vulnerable female patients and groomed those patients to become their sexual partners. She also bought shares in HC Surgical Specialists and showed up at the AGM of HC Surgical Specialists and informed the CEO and CFO in her capacity as a shareholder of her allegations of Dr. Ong's sexual misconduct. The problem was, it turns out HC Surgical Specialists was already aware of these complaints of sexual misconduct against Dr. Ong, and in any event, they decided to continue to proceed with the acquisition as a commercial decision. So Ms. Cheung, not stopping there, then brought a derivative action against the director of HC Surgical, alleging that he had breached his director's duties in proceeding with the acquisition of Mr. Ong's surgical practice. Now, unfortunately, much like ClientEarth, she also failed on the threshold and was rejected both in the High Court and the Singapore Court of Appeal. And it's very interesting here because they've pretty much failed on very, very similar hurdles to ClientEarth. The first thing was that they said, you failed to show that you were acting in good faith. And they said that she wasn't motivated by the interests of the company, but rather motivated by a desire to punish Dr. Ong by preventing him from receiving $3 million in consideration, and also to punish his friend, Dr. Chan, her former lover, by association. And the Court of Appeal said that this collateral purpose is inconsistent with the purpose of doing justice to the company and is in essence a flagrant abuse of the statutory remedy under the Singapore's equivalent of the derivative action. And while they recognised that she had suffered deep emotional scars, the Court of Appeal said the legal relief must come in, via the correct route, and the appropriate forum would be the Singapore Medical Council. The second point was on the matter of whether or not the directors had exercised due diligence, which is the equivalent, of course, of Section 174 of the Companies Act 2006. Ms. Cheung had argued that they'd failed to consider there was a real risk that the Singapore Medical Council's finding and decision on the complaint that she'd made might have a material adverse impact on the company. And ultimately, the court decided, as a matter of fact, the directors had considered it and essentially said, well, despite the fact that the sexual misconduct claim might very well be true, this company is making us a lot of money, so we're going to proceed with this acquisition. But as a matter of law, they also took a very traditional approach, much like ClientEarth, and said, well, it's not for us to second-guess the corporate decisions of those in charge of a company who believe in good faith that their decisions are in the best interest of the company, even if ultimately those decisions turn out to be money-losing ones. And it's not for the court to interfere so long as a decision is made in good faith. So very interesting and in essence quite different facts from ClientEarth, but the reasoning that they took in terms of not challenging the director's decision and sort of the collateral purpose were very, very similar. I mean, you can see sort of Ms. Cheung's argument that actually, as with ClientEarth, not having a material adverse impact on the company and also there not being sexual misconduct allegations might well be aligned. But of course, much like ClientEarth, that was very much shot down. I suppose, so that's sort of in Singapore. In the New York State courts, I'd say actually it was quite similar to McGorgy actually as a comparison, and it was ultimately dismissed on a very, very technical grounds, much like what happened on this side of the pond. So in the New York State courts, there was a case called Wong, New York City Employees Retirement System, and a lot of other retirement systems. This case is particularly interesting because we've seen with ESG claims, right? It's more about challenging them to take into account the environmental factors. Whereas what happened in the US in the New York State courts was that they were saying, you've taken into account environmental factors, you shouldn't take that into account, you should reduce that. And the claimants argued that the fiduciary duties that the retirement system or the people supervising the plans was for the exclusive purpose of providing retirement benefits, and they'd breached their fiduciary duties when they divested their pension plans of $4 billion in holdings in fossil fuel companies. Ultimately, what happened was the New York State courts dismissed the claim for lack of standing. So, like I said, very technical grounds, much like with ClientEarth with McGorgy. And to establish a standing, one must have suffered an injury in fact that is concrete, particularized, actual and imminent. And because these plans were a defined benefit plan, entitling them to a fixed payment each month, they said, well, the payments that are going to be made to you aren't going to actually fluctuate with the value of the plan or because of the plan fiduciary's good or bad decisions. So actually, you've got no stake in this lawsuit at all. You've not suffered a loss, which is an interesting way of thinking about it. You can sort of see the logic or the force of it. But it is quite technical, isn't it?
I wonder if it would be different if they were able to show that the viability of the plan and its ability to meet the defined payments was being compromised by the decision making. Because surely you'd have thought if you could show that the plan now left the decision making now left the plan insufficiently funded to meet those defined payments, that you might well have a claim.
I think it sort of depends as well on, if you're being very technical about it, the strength of the sponsoring employer. So did you say it was the retirement boards for public authorities?
For public authorities. And actually, it's quite interesting, Dan, that you say that, because the court said that was an argument that the claimants had made. And the court said, well, that's neither here nor there, because the taxpayer will fund it.
Yes, exactly.
Yeah, exactly. And I think it's quite interesting because the claimants were clearly alive to this point that potentially we won't be able to show loss and therefore we won't have standing to bring this claim. So they tried to put themselves in a position where they were analogous to trust beneficiaries and that they were part of a common law trust. And the court basically said, well, you're not, because you're still going to get your money and there's no analogy to be made here. And I thought that was, I suppose, quite an interesting one, because there's obviously with fiduciaries, it's not just directors, we've also got trustees. Saaman, I know you've done a lot of work advising fiduciaries, particularly trustees, as to the correct approach to ESG when making investment decisions. And I think there's also a recent case, isn't there, about the trustees going to a court for blessing for policies where their investments were going to completely align with the Paris Agreement, despite not maximizing returns. I mean, could you just walk us through that, through the state of law at the moment?
Yeah, thanks so much, Anson. So, as you said, I'm going to talk about the general principles which apply to fiduciary decision-making in this field. And what I'm not going to do is talk about the particular regulatory rules which apply to different classes of fiduciary. So whether that's those regulated by the FCA, the Pensions Regulator, or the Charities Commission, or other regulators, I'm going to focus on what the common law and equity tell us. Having said that, it is important to flag one theme within the regulatory backdrop. And it's this: regulators have imposed much more involved rules concerning disclosure around ESG factors. So whether that's how fiduciaries take ESG into account when exercising investment powers, or whether it's ESG disclosures by issuers around ESG matters, overall, the regulatory environment now across the world is such that a framework is being created to generate information which allows ESG matters to be taken into account. Now, having said that, we return to the common law and equity, and the correct approach by fiduciaries to dealing with ESG is determined by the application of conventional principles. And so the first thing you need to do is properly construe the power the fiduciary is seeking to exercise. Now, what I'm going to be thinking about here is typically fiduciaries with an investment power, so a power to invest the assets of the trust and generate return. It may be that investment power comes with express limits. So if your investment power expressly says no investment in fossil fuels, no investment in tobacco, no investment in arms, that's fine. You just construe the power and you apply it. But most of the time, fiduciaries will have a general power of investment. And if they have that general power of investment, there are three principles of fiduciary decision-making that become relevant: proper purposes, relevant considerations, and finally, the views of beneficiaries. So dealing first with proper purposes, it's trite that a power must be exercised for its proper purpose. This is the fraud on a power doctrine. And the leading case here is the 1985 case of Cowan and Scargill. So in that case, Arthur Scargill wanted the trustees of the miners' pension scheme to divest from all energy investments which might compete with the UK coal industry. And he wanted the pension trustees to do this to help protect the jobs of British miners. And actually, in this case, the judge was the Vice-Chancellor Megory, and Arthur Scargill appeared in person. The judge held that the purpose of protecting miners' jobs was an impermissible purpose. Exercising the investment power for that purpose would be a fraud on the power. And the judge held that typically in the case of investment powers, the proper purpose is simply this: to maximize investment returns, and any other purpose was impermissible. Now, that holds as a general rule, but it's not always the case. It might be that properly viewed, for some trusts, the purpose is broader. And I think the Butler-Sloss case that you were alluding to earlier, Anson, is a great example of this. And that case concerned the investment policy of two environmental charities. The trustees of those charities brought an application to the court to bless their momentous decision in relation to investment policy. And their decision was, as Anson flagged, that all their investments should be aligned with the Paris Agreement, even if this meant that investment returns would not be maximised. Mr. Justice Michael Green held that if the trustees reasonably formed the view that a particular investment conflicted with the charity's purposes, then it was entirely proper for them to choose to exclude that investment from the investment portfolio, even if it meant their returns would not be maximised. And actually, for me, in many ways, that's an unsurprising decision. The entire raison d'etre of those charities, their overarching purpose was to advance environmental goals. Their purpose wasn't like Shell to make money. And it would be really surprising if particular powers within this trust, whatever they may be, could be exercised in a way that was inconsistent with that purpose. But that's quite a special case. So assume you have that general investment power and you're not a charity or an environmental charity, and you've established your proper purpose, which is maximising investment returns. You must then take into account all relevant considerations and not take into account irrelevant considerations. And another way you might conceptualise the Scargill decision is that protecting miners' jobs is simply irrelevant when set against the proper purpose, maximising investment returns. Now, on its face, that might seem that it would conflict with the drive for greater ESG. But I think actually, this principle is perhaps the most powerful tool in the armoury of a fiduciary who wishes to exercise investment powers in accordance with ESG principles. And it's for this reason, it seems to me, looking in from the outside, that there is now an overwhelming weight of material to support the contention that climate change is at the very least a relevant factor to consider when it comes to investment returns. And it seems to me against that backdrop and against all the information that's out there, it's very difficult to see how a trustee exercising an investment power could properly justify entirely ignoring climate change. And as Anson said, we must also not forget the G in ESG. There's similarly a very heavy weight of material out there which supports the contention that properly run companies with strong governance functions, truly independent boards and so on, tend to do better in the long term, or at least that's a relevant factor to consider. But this takes us only so far. The trustee must take all relevant factors into account, but once he or she has done so, the weight to be placed on those factors and the conclusions the trustee comes to is a matter for them, and then that is subject to a relatively weak control of rationality. And once they've set their policy, perhaps, as ClientEarth sought to argue, exercising reasonable care in achieving that. So, assuming the trustees can demonstrate that they've properly taken into account all relevant considerations, if they decide that their investment policy is going to be drill, baby, drill, let's set the world on fire, it's very difficult, assuming that they've gone through the correct procedural hurdles, it's very difficult to challenge that. Similarly, if the trustees decide to adopt an investment policy that's aligned with the Paris goals, again, assuming that they've jumped through the right procedural hurdles, very difficult to challenge that. A final point that has been mooted in the case law is the views of beneficiaries. And here, to take a rather extreme example, imagine the trustees of a trust for the financial benefit of priests in the Church of England. those trustees might well take the view that their beneficiaries would not want them to exercise their investment powers in a manner contrary to the teachings of the church. And this was the idea floated in the Harrison Church Commissioners case a number of years ago now. I say this is a sort of mooted principle because the precise rationale for it is unclear. It could be a form of beneficiary consent or ratification or affirmation. If that's right, then really you'd need sort of all the beneficiaries to agree. And the difficulty you face is the difficulty in the one case. What happens if you adopt an explicitly ESG approach, even if that doesn't maximize investment returns, and there's a minority of beneficiaries who are opposed to that, and they could readily challenge that. So I think views of beneficiaries is a difficult route for trustees to go down unless they've got unanimity. But proper purposes and relevant considerations, those are the key elements of fiduciary decision-making that I think are relevant in this space.
It's interesting what you say, Saaman, if I can chip in at this stage. From what you say, a couple of themes for me emerge. One is that whether you're a company director or a trustee of an investment fund or pension fund, so long as you adopt a reasonable and rational decision-making process and that your decision-making is within those boundaries, which are pretty broad, then it will be very difficult to challenge your decision-making, whether that is decision-making in favour of a particularly pro-ESG approach or one which is less so. You're going to fall within that territory where the court is likely to turn around and say, well, that's for them, not really for us. That's one point or feature of your summary there that really landed with me. And the second is a sort of unifying theme of purpose, which seems to emerge in all of these cases and all of these concepts. And hearing Anson's comments on the cases from overseas as well, the courts are very alive and very sensitive to the real purpose behind challenge. And unless you can identify some significant financial harm that you are suffering, which wasn't possible in the New York case, possibly wasn't clear in the Singapore case, and will be quite difficult to establish, I would have thought, in most trust-type cases, albeit you've identified one where the trustees were effectively seeking the court's blessing to pursue a strategy which may well not be the most profitable. But the courts are certainly going to be looking hard at the evidence as to what's really behind the claim, aren't they? And there is a degree of sympathy to the professional here, the director, the trustee, in the discharge of their duties. And that unless the claimant is bringing it without any possible related purpose or ambition, you may well fall foul of the requirements of the threshold tests that the courts have identified. I mean, does that chime with you from your knowledge of the trustee cases?
Yeah, well, it seems to me that obviously the sort of underlying fiduciary principles are the same and they apply across the board. I think there's perhaps an unstated policy view in relation to companies that it's important that the UK remains an attractive place for companies to come and incorporate, and that you want to protect and insulate directors to increase that attractiveness. And that sort of underlying idea or notion doesn't apply in the same way to trustees and their decision making. But the difficulty is because of the similarities across the piece, you can't help but having sort of the approach to directors being applied in a similar way to trustees as well. I mean, there's also, I think, very interesting comparisons to be drawn between how the court reviews fiduciary decision-making and how it reviews the decisions of public authorities.
I was just going to say that. I mean, the language is so similar. And the latitude of decision-making, the concepts of reasonableness and rationality. In ClientEarth, we tried to sort of reintroduce those concepts, and in particular the concept of rationality into the requirements for director decision-making. It didn't land particularly well with the court. But it is a concept that you see rolled out. Indeed, one of the core anchors of the Wednesbury tests and the public law judicial review standard. And it's interesting when you see these concepts being applied in a variety of contexts, commercial and otherwise. I mean, it sort of brings these points together.
Dan, I was just thinking about the point you made about collateral purpose and how it seems like the courts are very, very alive to looking behind the claim and seeing what the purpose is. And I wonder if perhaps the reason, or I suppose the different sort of very traditional approaches the courts have taken to derivative actions, to challenges via claims against trustees have been so traditional versus the relatively lenient approach the Court of Appeal took to the Section 90, Section 98 FSMA claim, was that perhaps traditionally the courts and perhaps even Parliament have viewed derivative actions as for the purpose of challenging directors' actions for financial, where there's been financial harm, whereas Section 90, Section 98 FSMA was specifically created to allow shareholders to challenge persons discharging managerial responsibilities where they've caused loss and where there have been misleading statements, whether or not, for example, in the Standard Chartered case, that was to do with corruption allegations or breaches of sanction policy. So it didn't really matter that there was an ESG element so long as there was a loss suffered. And I suppose that's perhaps where the difference is when you compare the different approaches where claims have succeeded and where claims have not.
It's an interesting observation because Section 90/90A, Schedule 10A FSMA, these are not exceptional avenues of recourse. They are statutory as against the derivative action, which is expressly an exceptional avenue of claim. So, no, that certainly makes sense to me.
And I suppose the other aspect of the FSMA claims is that dishonesty is at the core of them. And I suspect that always leads the court to be a bit more generous to claimants where there's dishonesty at issue and there's a pleadable case of dishonesty. I mean, I just wonder how deceit claims will pan out in this context, Dan.
No, I think you're right, Saaman. I think if you can muster, if you're acting for a claimant, a pleadable claim of fraud, then that is going to get some traction with the courts and essentially you will be on the conveyor belt to trial at that stage, and you'll have your disclosure battles in the usual way. And if you're a defendant, if you're able to knock out that claim on the basis it's not arguable at an interim stage, then obviously that would be a very satisfactory way to deal with it. The last thing I'd say on this topic is it's important for the audience to remember that a claim in deceit will be available against a company director if they have procured the company to make a deceitful statement. And indeed, a claim in conspiracy can be brought as well. A director will not be able to turn around and seek to rely on the fact that it was the company making the statement, or as one judge once described it to me in a case, a doctrine of vicarious immunity. There is no such doctrine. If the director caused or knew that the misleading statement was being made by his or her company, then they will be liable in deceit.
Yeah, absolutely. Well, thank you everyone for joining us. If you're watching on YouTube, please don't forget to hit the subscribe button to stay updated on new episodes. For more expert insight, visit our website at 4newsquare.com.